please, my lords, my lady, I have been dealing with Article 2.1a and made some introductory comments. Moving on from there, we submit that even if our insider-outsider point, which I addressed this morning, is not correct at the headline level, as I put it this morning, the points we rely on in relation to it are all relevant to the construction of Article 2.1a and strongly suggest that the four scenarios covered by Article 2.1a that I mentioned to the court this morning all require a claim that originates with an outsider and would not include a claim for damage to the ship and consequential losses arising therefrom. As I have said, we accept that the damage to the cargo, in the sense I mentioned this morning, was a but-for cause of our losses, but we submit that that's not sufficient to engage Article 2.1a. My clients had no financial or other interest in the DVB or the other cargo which MSC rely on as constituting the damage to the property or loss of property, so as to engage Article 2.1a. The loss that owners suffered was, we submit, consequential on the damage caused to their vessel and not on the loss of or damage to the cargo. We would also suggest to my lords and my lady that if MSC's case was correct, then all of the loss and damage claimed by the owners in the CMA Jakarta case would have been limitable. So the court will recall that that was another container ship casualty with an explosion on board. I took the court through this morning. Crew abandoned the vessel, salvage services presumably towed to a place of safety because the cargo is then all discharged, sound and damaged cargo, and repairs take place. And if that degree of causal connection that we have in our case was sufficient, it would have been sufficient in Jakarta as well. In particular, which is one of the reasons I mentioned it to my lord this morning, the general average claim in Jakarta would have been limitable under 2.1a if the degree of nexus that we accept exists, that causal nexus, was sufficient. We submit that the proper approach to 2.1a is that consequential loss resulting therefrom, that provision, that wording, would be engaged if the owners of the DVB or other cargo, that is to say an outsider, had claimed direct losses and also consequential losses. So it assimilates, as the judge put it, the direct and consequential losses for limitation purposes. So as I said this morning, if cargo owners claim the value of their damaged cargo, and then, as in the Aegean Sea, also their share of salvage, for example, then that claim would be limitable. That approach is what Justice Finkelstein in the APL Sydney case referred to as the narrow construction. And could we just look at that Authorities Bundle tab 19, page 363. Paragraph 23 of the judgment. This is a case in which a pipeline had been damaged by the anchor of the vessel APL Sydney, which had been supplying ethane to two claimants, who were the two claimants in this action. And because of the damage, they suffered purely economic loss because they weren't able to operate their factories or they had to incur extra expenses. So, as my learned friend said yesterday, query whether the losses they were claiming would even be recoverable as a matter of English law, but that doesn't really matter. That's the Lord Diplock point that the judge was referring to in the judgment. But on the assumption that those claims were recoverable, Justice Finkelstein had to consider whether they were limitable. And he referred to a book, then in its first edition, but subsequently a second edition, in which the authors, Justice, as she now is, Derrington, and Mr. Turner KC, as he now is, of Quadrant Chambers, had suggested that there was the narrower construction and the wider construction, and their view was that it was finely balanced between the two, as recorded by Justice Finkelstein, they took the view that the narrow construction was better. That's paragraph 23. And Justice Finkelstein then said that with respect to the authors, he preferred the wider construction, which said that the claims of the end users of the ethane were limitable. And his approach to that was firstly to look at, we see at paragraph 25, Mr. Justice Thomas's decision in the Aegean Sea. And he says the ship owners made a claim against the charterer following the grounding of the vessel, I'm reading from paragraph 25, which resulted in her destruction and loss of most of the cargo of crude oil. There were several heads of damages claimed. And then over the page, he refers to Mr. Justice Thomas's decision in relation to some of the pollution claims. And he says, as regards the claims for indemnity, Mr. Justice Thomas said they fell within Article 2.1a, albeit they were unrelated to the damage to the ship. His reasons of Article 52 are short, and then he quotes the reasons. And if I could just ask my lords and my ladies to read the quote. And with great respect to Mr. Justice Finkelstein, he's misunderstood the approach of Mr. Justice Thomas, which, as we looked at earlier, was that the pollution claims did involve damage to property, that is to say, the fishing vessels and such like, and consequential loss as a result of that, that is to say, the economic loss because the fishing vessels were out of commission. And the damage to the fishing vessels and such like, caused by the pollution, was damage caused in direct connection with the ship. So that's how he got to limitability under 2.1a. So Mr. Justice Thomas was not, in our submission in the Aegean Sea, adopting what Justice Finkelstein called the wider construction. And then he also found support in the decision of Mr. Justice Sheen in the Braden Merchant, which is the case my learned friend took you to yesterday. And it is correct that in the Braden Merchant, if we could just turn back to the Braden Merchant, which is in tab 50. Tab 12. It is correct that in the Braden Merchant there were a number of claims, and we see this in the in the headnote at page 219, left-hand column, just opposite the lower lever arch. In addition to their liability to pay salvage, the cargo owners also incurred additional stevedoring and transshipment costs and additional freight. And Mr. Justice Sheen went on to consider the limitability of the claim in respect of salvage. The only thing one can say about the other claims is that Mr. Justice Sheen said nothing about them. So he didn't say they were limitable, he didn't say they weren't limitable. His judgment deals only with the claims in relation to salvage. And what he said essentially is that where a claimant is claiming indemnity in respect of a salvage sum they've paid, that is not a claim for salvage within the convention, and therefore it is limitable. And where a cargo claimant is claiming their portion of the salvage award, i.e. that part of the salvage award which specifically refers to salving the cargo, that is within 2.1a and also within 2.1f, and we'll come back to look at that again this afternoon, later this afternoon. But he wasn't saying anything wider than that, and so going back to Justice Finkelstein at page 364, at the end of paragraph 27, he correctly recalls that Mr. Justice Sheen did not specifically address the additional stevedoring and transshipment costs. This is the last sentence of paragraph 27. And then says, but treated them as part of the cargo owner's consequential loss. And there's simply nothing in the report, with the greatest respect, that justifies that conclusion. He dealt with the legal argument advanced in the case relating to salvage, and there's nothing in the judgment at all relating to the other heads of loss. And so the two grounds that Mr. Justice Finkelstein relied on to reach his conclusion where he preferred the wider construction are, with respect, both flawed. We suggest that he should instead have held and we invite my lords and my lady to hold that consequential means consequential losses suffered by the party whose property has been damaged. As I said earlier, they don't create a fifth category of limitable claim under Article 21A. And if that's correct, MSC's reliance on 21A falls at that hurdle. But even if Justice Finkelstein is right and the phrase consequential loss resulting therefrom has the wider meaning, so as to cover a claim for pure economic loss consequent on property damage, and that's how the judgment is summarised in the headnote at page 357 of the bundle. And the judge considered, our judge at paragraph 57 of his judgment considered that was a correct summary. So assume against me that consequential loss resulting, pure economic loss consequent on property damage is limitable. That still requires that the party harmed as a result of the DVB or other cargo being lost should have some kind of interest in the DVB or other cargo. So on the APL Sydney example, although they didn't own the pipeline, the users of the ethane had an interest in the pipeline and in the pipeline remaining sound, so it would supply ethane to their factories.
They had an economic interest.
They had an economic, indeed. And as the judge observed, I think he used exactly that phrase at paragraph 67 of the judgment, my lady, which I was coming on to. My clients didn't have any economic interest in the DVB or the cargo. Our economic loss, or our economic interest was in the vessel, and our economic loss was caused by the damage to the ship. So even if the wider construction is correct, the redress we seek is redress in respect of loss and damage to the ship, and not redress in respect of loss and damage to the cargo. So put another way, and this is the judge at paragraph 72, the cargo suffering loss and damage was not as such harmful to Conti, save insofar as Conti was liable to those for whom it was harmful, i.e. the cargo owners. And so for all of those reasons, we say that the reliance on Article 21A is misplaced. But even if Article 21A is potentially engaged, we submit that there's a yet further bar to MSC being entitled to rely on it. And that's that all four heads of claim were in fact incurred as a result of the damage to the ship. And that is a loss which is not limitable. Now, MSC in their skeleton argument at paragraph 70, which it may be useful to turn up page 288 of the core bundle, suggests three possible answers to the question that arises where a loss might be said on one basis to be limitable and on another basis to be not limitable. So they say the question is posed at paragraph 69. The question gives rise to a question, paragraph 69, which is relevant in the present case, namely, is a charterer entitled to limit his liability under 21A for the damage that is caused both by damage to the ship and by damage to the cargo? And they suggest three possible answers. Now, we of course say that the question doesn't even arise, but if it does, then the answers, we deal with them as follows. Possible answer one is that any substantial causal relationship with the damage to cargo is sufficient. And in our submission, that can't be right. If it was right, it would work for all of the losses we claim, because there would be any substantial causal relationship. So possible answer one is not correct. Possible answer two is that any substantial causal relationship with the damage to the ship means that the losses are not limitable. And we say that that is the correct answer. And we say it's the correct answer because if you have any substantial causal relationship with the damage to the ship, our claims are in essentially for damage in respect of the ship. The key reason or the key factor is why the claimant, i.e. my clients, incurred the loss. And if there's any substantial causal relationship with the damage to the ship, it's not a limitable cause. So possible answer three, suggested by my learned friends, is one that identifies what he calls the proximate cause of the loss. That in our submission is not the correct approach. As the judge said at paragraph 57, page 60 of the core bundle, the focus should be on the nature of the claim, not on the mechanism of causation. A causal connection on the facts does not turn a claim for damaging the ship into a cargo claim. But even if that was the right approach, we would submit that certainly on appeal, that doesn't assist MSC because they don't have any finding of fact as to what was or was not the proximate cause. They do not in particular have any finding that any of the loss and damage that they now seek to bring within 2.1a was proximately caused by the loss of or the damage to the cargo. For each of those claims that are now in dispute, or the limitability of which is now in dispute, we spent the money to get the ship repaired, as I've already said to my lords and my lady. So that is yet another hurdle, but if there were any remaining doubt, then we say, as the judge said, paragraph 73 to 76 of the judgment, that the Travo do assist in confirming, and in this context I will say in confirming the meaning that we say is already clear. So without as much trepidation as before, if I can ask my lords and my lady to look briefly at bundle A, tab 23, which is file 3 of the authorities bundle at page 967. I think I already read paragraph 22. This morning it was explained that 1A of this draft deals with physical damage and person injury. But could I ask the court this afternoon to turn to internal paragraph 400 at page 968 and to answer the question my Lord Justice Mayles put yesterday. The wording that is being considered is materially identical. There is a difference. The words aids to navigation do not appear in the parenthesis, but I don't think that affects my Lord's and my Lady's consideration. The court could read just paragraph 400 down to the words lack of a better word.
So sorry, which page was 400?
968 of the bundle. Oh. Right at the bottom of the page.
Oh, there, sorry, just got it back.
So, in essence, we submit that what this shows is that the words, the reference to consequential loss, was there to provide clarity, to make clear something that might already have been understood but was not clear, that the claims for consequential loss resulting from the direct losses covered by Article 2.1a would be limitable as well. And that, in our respectful submission, supports the narrower construction of the two constructions considered by Justice Finkelstein, but in any event, it is contrary to any suggestion that the wider construction can assist MSC in this case. So, looking in conclusion at the groups of claims which MSC says are within 2.1a, costs of the passage to Wilhelmshaven, these were sums that had to be paid in order for the vessel to proceed to a port of refuge in circumstances where she could not complete her voyage because of damage to the ship. They were predominantly required because of the risk of bunkers escaping from the damaged vessel. They were also required in order to repair the vessel, and they're not consequential on the loss of or damage to the DVB or other cargo. Costs of discharging, cleaning, storing, transshipping and releasing the cargo were all incurred in order to prepare the ship for repairs. So they're not consequential on the loss of or damage to the DVB and other cargo. The same is true of the costs of the firefighting water and the cost of removing the waste, which also had to be removed to enable the ship to be repaired. all of which were in any event a consequence of the ship being damaged. And the correct conclusion we submit, therefore, is that none of the claims are within the ambit of Article 2.1a. So, moving on to 2.1e and f, a preliminary point that applies to both is the question of whether the considerations we've just looked at in the context of 2.1a, i.e. that it being damage to the ship and consequential loss, prevent my learned friend coming within 2.1e and 2.1f as well. I've touched on this slightly this morning, but I just want to develop one point, if I may. My learned friend's argument was that what Lord Justice Longmore said in Jakarta applies essentially only to 2.1a because it was focused on damage, and damage is not an ingredient of 2.1e and 2.1f. But in our respectful submission, at a headline point, my learned friend's point is simply wrong, because the fact that a claim is properly characterised as being one for damage to the ship or consequential loss, we're not saying that it's that per se that prevents it being limitable, but it's that per se that means it's never going to come within within F and E when it can't come within A. And so to make that good, if I can ask my lords and my lady to have a look at the Call for Appeal in Jakarta again, at authorities tab 15. And particularly at paragraph 33 and 34. Are the conclusions I took the court to this morning, and they are not phrased, particularly the passage in 34 that I took the court to, and 35, they're not phrased simply by reference to 2.1a. These are general findings that because the damage was caused, or the claim was for damage to the vessel and consequential loss, it was not limitable. And if one looks at the conclusion in relation to salvage at paragraphs 29, beginning at 274, going over to 275, Lord Justice Longmore's conclusion related to 2.1a and 2.1f. So he was considering whether the claim to recover an indemnity in respect of salvage payments was limitable under 2.1f. And he said the same considerations apply. So he has four square dealt with my learned friend's point, i.e. Court of Appeal in Jakarta expressly said that where the claim was for damage to the ship or consequential losses, then it did not engage 2.1f. And just on that point, and again, just to reprise something I said this morning, but add something to it, the court will recall that Lord Justice Longmore concluded by saying, I cannot at the moment easily think of any other category where limitation is likely to apply. And I think my Lord Justice Males said, was that, put to my learned friend, was that a lack of judicial imagination? But the fact of the matter is, I took the court to this morning, there were 8 other claims under the heading of damage to the vessel. The court was considering a case in which there had been an explosion, a fire, abandonment of the vessel, salvage, discharge of containers, sound and damaged, and repairs. And yet, even with all that background information, Lord Justice Longmore couldn't think of any claim that would be limitable. And so all of that strongly suggests that the conclusion that we urge in relation to 2.1a applies equally into 2.1e and 2.1f. And further, just while we have Jakarta open at page 274, left-hand column, middle of the page, I took the court earlier to the passage that says, while I entirely agree with the passage from Aegean Sea, that this is where Lord Justice Longmore gets towards his conclusion that because the claim is for damage to the ship, it's not limitable. And he does that in the section of his judgment where he is considering Article 9 and 11 of the Convention and Article 2 generally. He has not yet come on to consider Article 2.1a. So at this point, i.e. it would be surprising if you could limit by reference to the tonnage of the vessel that you've damaged. It is certainly in Jakarta taken to be relevant to the whole of Article 2, not just to 2.1a. And for that reason, moving to Articles 2.1e and F, we submit that the fact that the claims are for damage to the vessel and consequential loss resulting therefrom prevents the claims being within 2.1e and 2.1f as well. So taking 2.1e first, to be entitled to limit under this paragraph, MSC must show that some identifiable part of the claim we made was a claim in respect to the removal, destruction or rendering harmless of the cargo on the ship in the context that those words are used in the Convention. Again, this is a claim where previously MSC had relied on this head for a limitation in relation to a number of our claims, but now it is only relied on, as I understand it, into relation to discharging, storing, transshipping, etc. In their skeleton argument, again, just as a matter of language, the heading that these costs were all placed under was discharging, cleaning, storing, transshipping and releasing the cargo. So these costs on MSC's own case cover a large number of activities, including transshipping. They sort of shorten that in many places to discharging and decontamination. And on occasions they use an even shorter phrase, cargo operations. But it is important in our submission that the court looks at what these claims actually involved, which is all of those matters, discharging, cleaning, storing, transshipping and releasing the cargo, and considers whether they come within the meaning properly given to Article 2.1e. And it is correct, as my learned friend said, that through a process that occurred during the trial of amending our response to the claim, various costs in this group of costs were identified as being not properly categorised, and they were moved into other heads. But even after that, as I said to the court when I was looking at the key facts, the vessel remained at Wilhelmshaven incurring berthing costs long after the discharge was completed. And that cost forms part of the costs claimed under this heading. And it's difficult in our submission to see how that claim can come within the rubric of 2.1e, whatever else might be said. So, against that background, the first point is the same first point as in relation to 2.1a. Even if we're wrong on the inside or outsider point at the headline level, we still say that the purpose of permitting charterers to limit was to ensure they could limit for outsider claims for which the ship owner could limit. And that in that context, Article 2.1e, like 2.1d, means a claim by some third party, such as a harbour authority, in respect of costs incurred by that third party in removing or destroying the cargo or rendering it harmless. And it clearly does not include a claim by the owner of the damaged ship for costs incurred by that owner to remove cargo, particularly in circumstances where the cargo had to be removed before the damage to the ship could be repaired. And as I've already noted, MSC agrees that the ship could not have been repaired without the cargo being discharged, so that, and I'm quoting, this was at first instance, I'm quoting from paragraph 117 of the judgment, page 75, MSC accepted that the discharge costs could, quote, fairly be described as costs that were ancillary to the repair. So these are costs that are ancillary to the repair. And we say they are therefore properly characterised as costs of repairing the ship, and consequential loss arising from that and therefore not limitable. Now, in response to that, my learned friend, I think, said yesterday that articles D and E, or subparagraphs D and E, would always involve some kind of damage to the ship. So that if we're right, articles D and E would virtually never be engaged. And with respect, that is again to confuse causation with characterization. Yes, it is true that in the widest sense, one will never be in wreck removal territory, i.e. within D and E, unless there has been some damage to the ship. I suppose there could be a pure case of jettison of cargo, which might come within E, where there is no damage to the ship, but you are unlikely to jettison the cargo or be permitted to do so unless there's a threat of damage to the ship. So there's nearly always going to be some damage. But that of itself is irrelevant. There can still be claims in which subarticles D and E will be engaged, as I said, for example, a claim by a harbour authority. So the fact that in its widest sense there is damage to the ship and that is causative of the incident having occurred, that's not what prevents articles D and E being engaged. What on our case prevents articles D and E being engaged is that the fact that the costs are costs in respect of that damage to the ship. So, to put the correct example, if you have a large number of containers washed up on the south coast of England from a stranded and damaged container ship, then you've still got damage, but the cost of removing them from the beaches is not a cost that's incurred in respect of damage to the ship. So that is limitable. So the fact that there will always be damage to the ship does not prevent paragraph D and E being engaged in appropriate cases. And we would suggest that the facts of this case in fact illustrate how Article 2.1d and 2.1e might be engaged. As the court's aware, we threatened to abandon the vessel and constitute a fund in Germany. If we had done so and the German authorities had taken over the vessel and discharged the cargo, then any claim by them against us would be limitable under the convention. Again, I have to say under the convention because it would be 2.1d, which is not part of English law. And MSC suggests that that distinction is arbitrary, and they say that counts against our construction. But with respect, they overlook two very important points. The first is that, as a matter of fact, we did not abandon the vessel. We pushed ahead with our plan to repair the ship, the plan that we had formulated even before the vessel arrived at Wilhelmshaven. We incurred and paid the discharge costs in order to be able to do so. The German authorities paid nothing. And it's, with respect, pure speculation to assume that if we had abandoned the vessel, the same costs would have been incurred. So it can't be said, here's a claim for X euros that is limitable if the German authorities bring it and not limitable if Conti bring it, and that's somehow arbitrary, because that assumes it would be the same claim. But the German authorities would have been removing the cargo for an entirely different reason. They would have been doing so pursuant, presumably, some duty under German public law of the local authorities to clear up the wreck. They would have had no interest in doing so in a manner that permitted the vessel then to be repaired. They would have had no interest, particularly, in decontaminating and transshipping sound cargo, or in enabling the contracts of carriage on the MSC bills of lading to be completed. Their interest would have been fundamentally different. They may or may not have discharged the vessel at Wilhelmshaven. They may or may not have incurred the same costs. They may or may not have been required to keep her there for as long as she was there. We simply don't know what that claim would have been. But in any event, it would have been a very different claim to the claim my clients bring, because the reason why the German authorities incurred that cost would be in their capacity as the authorities with an obligation to do so. Whereas the reason my clients incur the cost is as owners of a damaged ship. But if I need to push the point any further, as to whether there's that distinction between if the ship is abandoned or not is arbitrary, I ask the court to have page 100 of the authorities bundle open, Article 2. And to note that for the purposes of Article D, paragraph D, certainly paragraph D, paragraph D is only engaged if the ship is sunk, wrecked, stranded or abandoned. So a decision to abandon will trigger Article D. So if the question of whether the owners abandoned the vessel or not is somehow capricious or arbitrary, that's a distinction that Article D requires you to make in any event, paragraph D. And we would suggest that the interrelationship between D and E, that the reference in E to the ship must be a reference back to the ship that's been abandoned, sunk, wrecked or stranded. That's a further reason why Article 2(1)E does not apply. But it also means that, again, the consideration of whether the vessel has been abandoned is built into the convention, and therefore there's nothing surprising about the result turning on whether the vessel's been abandoned.
Sorry, I think this is a new one. Are you saying that E only applies where the ship has been sunk, wrecked, stranded or abandoned?
Well, the reference to the ship has to be to either the action. My lord, no.
No. Surely we have the ship in
the
A,
ship, yeah,
in
my
D.
lord.
I mean,
I should have made that submission only in relation to Article D. But certainly in relation to Article D, the court has to consider whether there's been an abandonment. And therefore, the need to consider that can't itself be a reason why our construction is wrong. The next point MSC takes is that our construction is apt, they say, to create difficulty in practice. Because again, they say it all depends on the owner's intention. But on our case, the reason why there's no right to limit is because the payments have been made as a matter of fact by the owner for the purposes of repairing the ship. That's a very easy test to apply. The expenses have been occurred, the judge's wording was on behalf of the ship. But on MSC's case, there's a right to limit, very generally in respect of removal, etc., that requires one to look at a package or portfolio of costs incurred by the owners to unpick all those costs, to audit and identify those which are really costs of removing and destroying the cargo and rendering it harmless, or costs that are in fact related to the repair. Where costs are incurred for two reasons, and this goes back to the point I made earlier, it will require an inquiry into what is the dominant purpose or the main purpose or the most significant purpose. I think those are the three different phrases my learned friends use. Depending on which of these formulations appear, are applied. And that is a process that the Convention simply doesn't envisage. There's no reference to costs, claims in respect of, or claims predominantly in respect of, or claims significantly in respect of. 2(1)E requires claims to be in respect of removal, and that in our submission means only of removal. And we submit there's nothing wrong with that as being the answer, because costs of repair caused by the damage to the vessel are conceptually different to costs incurred simply for the purposes of removing and destroying the cargo in a wreck removal context. It's also, in our submission, again, back to the Travo and the previous conventions, important to bear in mind the history and the context of Article 2(1)E when construing it, to see whether the word removal really does cover, as my learned friend suggests, discharge in what we say is not the ordinary way, because the vessel is damaged, but discharge of the cargo. And so, if we could just turn back to the 1927 convention,
Sorry, 24 or 57?
24. I apologise. 24 to start with, and I showed this to the court this morning, just to remind my lord and my lady that what was limitable under the 24 Convention is any obligation to remove the wreck of a sunken vessel and any obligation connected therewith. So this is where the owner of the ship or the principal charterer is under an obligation to remove the wreck of a sunken vessel, or an obligation connected with the wreck of a sunken vessel. For example, to pay the costs incurred by a harbour authority that has raised sunken wreck. And so we would accept that this article would at least arguably encompass, as I've said, an obligation to meet costs incurred by a harbour authority in removing or rendering harmless the cargo of a sunken vessel. But it would not cover,
only if the vessel is sunk, though.
only if the vessel is sunk.
It wouldn't cover our case.
It wouldn't, my lord. I was coming on to make precisely that point. It would not cover any kind of cargo operation where there was no removal from the vessel. And it would not cover our case because we don't have a sunken vessel. But the right to limit in wreck removal cases is widened by the 1957 Convention, again, as we saw this morning. At page 23 in the authorities bundle, any obligation or liability imposed by law relating to the removal of a wreck and arising from or in connection with the raising, removal or destruction of the ship which is sunk, stranded or abandoned, and any obligation or liability arising out of damage caused to harbour works. Well, we can miss out the last bit. We're not concerned with damage caused to harbour works. But this is a right to limit given to charterers where they're limiting in the same manner as an owner in relation to a liability imposed by law relating to the removal of the wreck and arising from or in connection with the raising, removal and destruction of any ship which is sunk, stranded or abandoned. Now, again, we would accept that that article could at least arguably cover cargo handling where there is an operation to raise or remove or destroy the ship, i.e. something one might generically call wreck removal, as I have been doing. But that's only the removal of the cargo. It would have to be something that was in connection with the raising, removal or destruction of any ship. So if you're raising the ship and you need to get the cargo off to do so, that's where you're within. But it would not cover...
So although you said, I think you told us this morning that C becomes D and E, once you accept that E covers cargo removal of a ship which is not sunk, stranded or abandoned, then E has in fact gone wider.
My lord, yes. I accept that, and I'm coming on to say that.
Yeah. Okay.
But the 57 Convention would not cover the situation that we're in. And then, as I said to the court this morning, Article 2(1)D of the 1976 Convention is materially the same as the provision of the 1957 Convention. The wording is slightly different. It's claims in respect of rather than any obligation or liability imposed by law. But as my lord has just pointed out, the Travo, which we looked at earlier, made it clear that D and E together were intended to be, the phrase used in the Travo is the equivalent of the 1957 Convention. So that doesn't mean the same as. I accept that equivalent of means this is what we've got in place of it. But we would still suggest that what is involved in 2(1)D, if we now turn it up in 2(1)E, is still an obligation on the part of the claiming party to incur what are, broadly speaking, wreck removal costs, or to reimburse wreck removal costs to some third party. So D is engaged, clearly we would submit, where the third party has incurred the wreck removal and similar costs. So costs of And E is in respect of claims in respect of the removal, destruction, or rendering harmless of the cargo. And that means a claim by an outsider who is engaged in that process, rather than somebody involved in the operation of the ship. And that is essentially the construction that the judge adopted, looking A, at the fact that my clients incurred these costs in the operation of the ship in the context that they needed to clear the cargo off the ship to repair her, and B, in the context that these costs were incurred in the operation of the ship because the cargo needed, so far as possible, i.e. so far as it wasn't damaged, to be handed over to its rightful owners in due course. I've made the point already as to whether that was my client's obligation to deliver the cargo or MSC's under their bills of lading, but clearly a motive for discharging the cargo is to enable it to be transshipped and on-carried to its final destination. That's the sound cargo. And all of these...
What if the charterer incurs the costs of removing the cargo, which didn't happen but might have done because MSC is the contractual carrier and it has obligations therefore under the bills of lading? Suppose it incurs the costs of removing the cargo and wants to claim those from the ship owner. Now, that's an insider claim, but it doesn't fall foul of your insider-outsider argument because it's going in the right direction. Is that within E?
My lord, no. Insofar as if what the charterer, but the phrase the judge used was on behalf of the ship. If these are costs that are being incurred on behalf of the ship, and that's why I said in our case there were two respects in which the costs were on behalf of the ship. Firstly, to get the ship repaired, and secondly, to get the cargo off so it could be on-carried. And that second limb would apply if the charterer were discharging. So they're undertaking a task that needs to be performed for the ordinary purposes of the ship's trade. Now, it's out of context because it's a damaged ship, but it's still discharging the cargo. And perhaps I illustrate it by using the word discharge. So that's a cost of discharge rather than a cost of removal in a wreck removal context. So this is removing, destroying, or rendering harmless the cargo, rather than discharging it in the sense of getting it off the ship to carry it to its destination or to deliver it perhaps at the port of refuge to the owners. So that is the distinction that we say is material. If we could just look, please, at the passage in the Travo that we did touch on, I think briefly this morning, at page 980 from the third file of authorities, so page 3. So we've already looked at the top of 980 at 404. D and E are the equivalent of Article 1, are necessary in addition to the previous subparagraphs in order to make claims for wreck removal and removal of cargo subject to limitation. That goes slightly to the point that I dealt with this morning as to whether Article 2(1)A was essentially the lead right to limit. And what is being said here is, well, you've got 2(1)A, but then you need these two paragraphs, D and E as well, in order to make claims for wreck removal and removal of cargo, the subject of limitation. And then, as you were taken to yesterday by my learned friend, paragraph 28 at the bottom, a suggestion was made that 1D and 1E might be one subparagraph, but the committee accepted the view that two subparagraphs were concerned with factual situations which might be distinct, e.g. the cargo might be jettisoned or otherwise detached from the ship, and this change was not made. And my Lord Justice Males made the point yesterday that at this stage, the wording of D did not include the reference to anything that is or has been on board. It was simply anything that is on board, and that therefore, I think my Lord's point was that D has now been amended to cover anything that has been on board, the final version of D, and that therefore E wouldn't be necessary if it was simply referring to the jettison point. And in our respectful submission, that is not the correct construction of how these two paragraphs work together. Article D, so paragraph D, is dealing with anything other than cargo that is on board or was on board, and the additional words in D referring to is or has been on board cover the situation, for example, where bunkers are on board the vessel or have been on board. So a bunker clean-up cost would be within 2.1d. Cargo is dealt with separately in E, and the reason you need E is the reason given at paragraph 28 to make it clear that by the time it has to be removed, etc., it might have been jettisoned or otherwise detached from the ship. And to make that good, can I show you in the Aegean Sea how Mr. Justice Thomas dealt with the bunker claims. Page 236, the right-hand column. At the very last paragraph, he said the claims for pollution caused by the bunkers and the claims for pollution caused by the cargo would also fall within 2.1d and E respectively, insofar as they related to the clean-up or prevention costs. So insofar as one is cleaning up bunkers, that's 2.1d, and insofar as one is cleaning up the cargo remnants that might cause pollution, that is 2.1e.
So under E, cargo extends to something which is no longer but was cargo. I mean, the pollution caused by cargo is, by definition, cargo that has leaked from the ship, isn't it?
My lord, yes, but might or might not still be categorised as cargo.
No.
I had a lengthy debate in front of another division of this court last year about whether something could cease to be cargo just because it was no longer on board the ship. So I'm reluctant to go any further on whether it ceases to be cargo simply because it's not on the ship anymore. But it's cargo that E, specifically by its wording, covers a cargo that was on board the ship and is no longer on the ship.
Yes, well, I wasn't trying to get into a debate about whether it ceases to be cargo, but it is fuel which was cargo and has leaked and is therefore causing pollution damage in that way.
Yes. And removal in this context doesn't mean removing something from the ship in the ordinary way that it needs to be removed, either to discharge it, to give it to its owners, or in the extraordinary way it needs to be removed from the ship to permit repairs. Removal in this context, and again the Aegean Sea illustrates this, is you're removing something from where it's gone to where it shouldn't ever have been. So it's removing the polluting cargo. On my other example, if this container vessel is stranded and the cargo has washed up on the beach, it's removing the cargo from the beach. So removal in the context of these two provisions, which even if they don't directly, even if they're the equivalent of the 1957 Convention, but slightly wider, removal in the context of these provisions does not mean removal from the ship for ship purposes, or as the judge put it, on behalf of the ship. It means removal as part of, as I've put it, a wreck removal operation. So whether that's you have a stranded ship and you're removing the cargo because you want to get her off the rocks, for example, or whether that's because you've got a sunken ship and you're removing the cargo because you don't want it to pollute, or whether it's because you've got jettisoned cargo or cargo that's been washed overboard and washed up on the beach and you're removing it from the beach. Those are all the items that D and E are related to, not to discharging, which is essentially what was undertaken by my clients in this case. And again, when one puts these provisions into context, and into the context of why the charterer is permitted to limit, if I'm wrong on the headline point, on the insider point, again, these provisions envisage, certainly when a charterer is seeking to limit their liability, a claim originating from outside the genus by somebody who has done this job, a local authority or a wreck removal organisation. Now, my learned friend says that our approach puts a gloss on the wording of the convention, and he says a gloss of uncertain ambit. We disagree. We're not seeking to put a gloss on these wordings in the sense that adding the words qua owner that Mr. Justice David Steele did in the Jakarta case. That was a gloss. What we're seeking to do is to focus on the words of D and E and see what they really mean. And that, in our submission, is removal rather than discharge in that ordinary sense. And my learned friend gave 4 examples that he said illustrated that our gloss, as he put it, was of uncertain ambit. And I'll just deal with those if I can. Firstly, he posited the position of cargo being removed by a public authority, but on behalf of an owner. And I've touched on this earlier in a different context. We don't see how the on behalf of an owner ever arises. If a public authority is removing the cargo from a vessel or removing cargo from a beach, it is doing so because it no doubt has some kind of public duty to do so. I find it difficult to imagine that it would ever be within the statutory or other bounds of a public authority's authority to act on behalf of the owner. They would do it for the public purpose for which that authority exists. And if the Harbour Authority is acting in that public capacity, then it's an outsider claim. It's engaged in wreck removal of some kind, and either D or E will be engaged. But if, on the other hand, the owner is incurring these expenses for themselves, then you are going to be outside D and E. The second posit my learned friend put was, what if the owner does the work, but on the instructions of the public authority? How does that work? Well, if the owner does the work on the instructions of the public authority, and only on their instructions, so they have some power to compel the owner on pain of the beneficial owners or the managers perhaps facing a fine or going to prison, then that power to compel exists for a reason, a public policy reason that the public authority engages in. And that then quite rightly means that the nature of the obligation being discharged is fundamentally different to what happens when the owner makes a decision of their own volition to repair their damaged vessel. So again, the cost on this posit would not, if the authority has the power to compel, would not be one in respect of repairing the damage, even if the owner then happened to repair the damage. The reason he would be incurring those costs was because he was told to do so by the Harbour Authority. And there's no issue with that, taking what would otherwise be a non-limitable claim if the owner incurred the costs for the sake of repairing the vessel, to make it into a limitable claim where the Harbour Authority requires him to do so. The next example my learned friend gave was stevedore engaged on the order of the authority, but for the account of the owner. Now, insofar as the stevedore said, please may I have my money for doing the job, that would not be limitable because, I've got my reference right before I give it, under Article 2.2, which says that claims on a contract are not limitable. So the stevedore's contractual remuneration for doing so is not limitable and is presumably paid by the authority, who then seeks to pass the bill to the owner. But in that respect, everything once the authority has paid for it is the same as in the previous example. If the authority has done this work using a stevedore, then the authority has incurred that cost for the public purposes for which it's permitted to incur such costs. And there's no reason why that shouldn't be limitable within D or E, not D in the United Kingdom, D or E as appropriate. But that again is fundamentally different to an owner incurring those costs for the purposes of repairing the damage. And then the final example my learned friend gave was a bill of lading holder removing the cargo. But again, we don't see how that can really work in practice. The bill of lading holder is going to remove the cargo because he wants his cargo and is potentially obliged to discharge it. So it's not within 2.1D or E at all. He's simply performing an act that he would have performed in any event. But it certainly isn't removal in the sense envisaged by D&E. It's just, again, a ship, an obligation undertaken on behalf of the ship, again, to use the phrase that the judge used. So we submit that in all the other cases, specifically when the owner incurs costs, so by all the other I mean other than public authority or third-party cases, specifically when the owner incurs costs in discharging the vessel, there is no right to limit. There is, as my learned friend said, a right to limit in the circumstances which Mr. Justice Thomas dealt with in relation to the recourse claims in the Aegean Sea. And we accept that those are within 2.1E. But that, as I've mentioned already when we looked at the Aegean Sea earlier, is because they're for the cost of removing the cargo from where it's washed up. So that is the cargo, to take my Lord Justice Mayles' example, has been removed from the vessel, is causing pollution. And that is being removed. It's not being removed from the vessel, it's not being discharged. It's being removed from the beaches or the seabed, where it is causing economic damage to those making their living on the coasts of Spain. So that is why, in the Aegean Sea, the cargo removal costs in that case were limitable under 2.1E. And that, in fact, in our submission illustrates why the cargo discharge costs, as we would label them, are not limitable in the present case.
I can see why removal in E would not encompass the ordinary discharge of cargo. Suppose the vessel arrives at the discharge port, the charterer has an obligation to discharge, but it simply refuses to do so. So the owner does it and incurs the costs and claims it from the charterer. There's no question of any casualty or damage or anything like that. I can see that that would not be within E, because removal takes its colour from the other words, destruction or rendering harmless. I suppose the ordinary case is a bad example anyway, because it's hard to believe that the costs of discharge would ever engage the limit. But leaving that aside, but why is removal? Does removal not include an operation which is necessary as a result of some casualty affecting the vessel or the cargo?
Firstly, because, again, just to put the points in order, firstly, because it requires, even if I'm wrong at the headline level, an outsider involvement. It has to originate outside. Secondly, because looking at the history and purpose for which the charterer is given the right to limit. So we're talking about limitation by the charterer. That intention is, again, to give them the right to limit in respect of a claim that the owner could also be liable for, so that the claiming party can't circumvent the owner's right to limit by claiming against the charterer. And thirdly, because, as Mr. Justice Thomas said in the Aegean Sea, Mr. Justice David Steele and Lord Justice Longmore said in Jakarta, and Lord Clark said in Ocean Victory, it's difficult to imagine that the intention was ever that charterers should be entitled to limit by reference to the tonnage of the vessel which has been damaged in relation to claims in respect of the damage to the ship. And even if the operation that is undertaken could be described in one sense as removal, we'd still call it discharge, but taking off the cargo, to use a neutral phrase without using removal or discharge. And if the operation of taking off the cargo could in one context be said to engage 2.1e, looking at the purpose for which that provision exists and looking at the purpose for which the charterer is giving the benefit of it, the correct construction is that having concluded that the claim is one in respect of damage to the ship or consequential loss, that it is not limitable. So these are essentially all the points that I've already made at other levels, but all of those points tell against bringing this claim within the ambit of the word removal, even if there is an element of, in some cases, rendering harmless the cargo. And again, it's a little artificial in our submission. We accept that part of this cost involved decontaminating the cargo in the sense of cleaning it up so that it could be delivered. But again, rendering harmless is a different context. Decontaminating so that you can deliver the cargo to its rightful owner if it's undamaged but needs to be decontaminated generally means cleaning up smoke damage, perhaps, or something like that. In some contexts, I suspect it could mean drying the cargo where it's been wetted but not damaged by the wetting. Getting the cargo ready to deliver it to the receiver. The word decontaminating or rendering harmless in the convention has a different tenor to it. And again, it's much more closely related in our submission to something like the pollution claims that were allowed under this heading by Mr. Justice Thomas. Because you're engaging with a process of removal, destruction, or rendering harmless the cargo. Because it's, for example, the paradigm example would be a potentially polluting cargo. If you've got oil on the seabed, or oil on the beach, or containers washed up on the beach, they need to be removed or rendered harmless or destroyed. And that's the kind of operation looked in the context of Article D as well. And in our submission, the judge was right to say that you need to look at E in the context of D. Because even if D and E go further than the 57 Convention when you look at them together, they are dealt with together, and they were dealt with together in the drafting process. And the whole context in which this right to limit appears is fundamentally different to the discharging operation that was undertaken at Wilhelmshaven.
Is this a new way of putting the case? I don't recall the judge addressing the point that what happened at Wilhelmshaven was actually not removal of the cargo at all, or is there some passage which I'm overlooking?
It's not intended to be a new way of putting the case, which, my lord, is why I started by saying, firstly, even if we're wrong at the inside or outsider level, at the higher level.
Yes.
And then secondly, by referring to the, it's actually properly categorised as damage to the ship or consequential loss therefrom. Those are both points that the judge dealt with. But if one picks up his judgment where he deals with cargo handling, this is paragraph 117 onwards. And at paragraph 124, returning then, so he's considered a little bit of a red herring that was set running in relation to whether these expenses would have been recoverable in general average. And he's dealt with that at paragraph 119 to 123. But then he says, returning then to the cargo handling costs at Wilhelmshaven. So he's using the neutral phrase, cargo handling costs. In this case, in the question of tonnage limitation, MSC says that to the extent that the arbitration award seeks to compensate Conti for having paid those cargo handling costs, Conti should be regarded as having made, quotes, a claim in respect of. And then he says, I agree with Mr. Smith, KC, that Article 2.1e should be read in conjunction with the immediately preceding Article 2.1d, even though that's not part of English law. Article 2.1d applies tonnage limitation to claims in respect of, and he then sets it out. Whether simply on its own terms, or when read with Article 2.1d, in my view, Article 2.1e does not have in mind at all the discharge or post-discharge handling of cargo by or on behalf of the ship. And that's why I use that phrase on a number of occasions in my submissions. Whether acting through her own crew and equipment or by shore labour, whether arranged by the owner itself or by a charterer. Or, therefore, claims as between the owner and the charterer regarding responsibility inter se for the costs of such cargo operations. So, my lord, I don't think I'm making any wider point than the judge was making there. We're simply saying, looked at in the context of two provisions that deal with wreck removal, they envisage something fundamentally different from an operation which the judge categorises as being by or on behalf of the ship.
Well, at 126 he includes cargo removal within E, where it is for casualty intervention or aftermath.
To which I would
suppose
attach
it's the
the
same
label.
kind of concept I was struggling towards.
Well, is the category of cases, the category of incidents to which I would have attached the label wreck removal of some kind, rather than discharge and post-discharge handling of the cargo on behalf of the ship.
Do we find any references to discharge as such anywhere in the convention? I mean, a counter-argument could be that discharge is just a subset of removal, looking at it purely as a matter of English without the advantage of any maritime context. But you're placing a lot of weight on the proposition that discharge, at any rate in the maritime context, has a well-understood meaning, which is well outside the apparent sphere of E as we have it here.
I think, with respect, I'm putting it slightly the other way round, which is that removal, in the context of D&E, which the judge held rightly in our view, and in our submission, need to be read together. Removal connotes removal in the context of a wreck removal operation.
Yeah, yes,
I'm not suggesting that discharge is a term of art that has a specific meaning. I'm using the word discharge, and the judge used the word cargo operation.
Yes, I see. Yeah.
In contradistinction to removal in the sense that they're used in the convention. So, looking at the convention and trying to identify the purpose for which the charterer has the right to limit in respect of these costs, and the context in which the charterer was given the right to limit in respect of these costs, does the word removal encompass within it what the judge has called ordinary cargo handling operations, or cargo handling operations on behalf of the ship?
Thank you.
And so, as I say, the judge went on not only to consider, just to add the final point in response to my Lord Justice Mell's question, as to why these are operations on behalf of the ship. As I've said, partly because they're operations to get the vessel ready for being repaired, and I've made that point already, but partly because they're operations in and about the performance of the contracts of carriage. I'm putting that in a neutral sense. The contracts of MSC bills of lading. I accept obviously that my clients as sub-bailees would have owed duties to the owners of the cargo. But again, this is all part and parcel, and the judge dealt with this at paragraph 132 and 133, where he looked at the charter party and considered briefly who might have been under the obligation to conduct the discharge operation, referred to the wording of the charter party and referred to an extract from Scrutton at paragraph 133. We don't need to and don't invite the court to reach any conclusion as to who was contractually obliged. But the fact is, these are operations that had to be performed by one or the other, I think as the judge put it, of the owner or the charterer. Not because of the casualty, but because they were going to have to be performed at some stage. And on that point, in his submissions just before lunch yesterday, my learned friend said, well, the judge shouldn't have been looking at the contract for this purpose, because Mr. Justice Thomas considered the contractual position between the parties in the Aegean Sea, and the judge said that he shouldn't have done so, and he was referring to a passage in the judgment at paragraph 96(1), where the judge said Mr. Justice Thomas shouldn't have been giving any weight to what was in the contract between the parties, or not in the contract between the parties. And could we just look briefly, this is my last point on E, at the judgment at page 96, paragraph 96(1) at page 70. And the paragraph that my learned friend was relying on, 96(1), was where our judge referred to what Mr. Justice Thomas said, that a claim by a ship owner against a charterer could be expressly limited by the terms of the charter party. And Mr. Justice Andrew Baker said he didn't think that was the correct approach. But that's a fundamentally different point with respect to the point that arises under 2(1)(e), which is that we are looking at obligations that are dealt with by the charter party, i.e. the obligation to discharge the cargo in the ordinary course of events. So it's a small point, and I thought I ought to just point out that the passage that Mr. Justice Thomas was, the point he was making that the judge criticised him for, was a very different point to the point I'm making now. And so, Ronald, can I just have 1 minute? Unless I can assist further on 2(1)(e), those are our submissions in relation to 2(1)(e).
Yes, thank you.
2(1)(f), to be entitled to limit under this paragraph, MSC must show some identifiable part of the claim we made, so one or more of the heads of claim, was a claim in respect of measures taken to avert or minimise loss for which the person liable, i.e. MSC, may be entitled to limit, and further loss caused by such measures. And MSC says that the payments to national authorities are in the first limit of that, i.e. claims in respect of measures taken to avert or minimise, and that the firefighting water discharge costs come within the second limb, further loss caused by such measures, on the basis that the firefighting water was put on the vessel to mitigate a limitable loss, and the cost of removing it is a further loss. And the first point, as I've said in relation to A and E, is that if we're right on the inside or outsider point, this falls away. But even if we're wrong, all the points we make in relation to that, including in particular the results that would obtain if a charterer could limit and rely on the same fund, and the history of the conventions, all colour one's construction of 2(1)(f). And so, against that background, we submit that 2(1)(f), like A and E, is intended to allow limitation by a charterer where the claims could also have been made against the owner who would have been entitled to limit in those circumstances. And 2(1)(f) is not intended to grant charterers a right to limit in respect of a claim by the owner for costs incurred by the owner that happen to have the side effect of minimising a loss for which the charterer might be entitled to limit, i.e. the potential cargo claims against the charterer. And that is particularly so, and this again is just to reprise the 2(1)(a) point, where the owner's motive for incurring those costs was to repair the damage to the vessel. And those are all covered by the findings of fact that I took the court to earlier. My learned friend relied upon the fact, he said the only case dealing with 2-1F was the decision of Mr. Justice Sheen in the Braden Merchant. And I said I'd come back to this in the context of 2-1F, and can I ask the court to have the authorities bundle tab 12, page 221. And 222, where Mr. Justice Sheen dealt with the claim to limit in respect of an obligation to pay salvage. So picking up at page 221, left-hand column, at the top of the page, is the reference to, sorry, I should have gone start on the previous page, the obligation at 220, right-hand column. Salvage services were successful. I'm right in the middle of the page, end of the paragraph. At the termination of those services, the salvors had a lien on the ship and the cargo for their salvage reward. In order to make it unnecessary for the salvors to exercise the lien, the insurers of the cargo provided a guarantee for a salvage award of up to £195,000. And I don't think we see anywhere expressly how much was paid in relation to the award. But the main debate in this case was whether it came within the exclusion from the Convention of claims for salvage. If we go back to the Convention at page 100, Article 3 provides that the rules of the Convention shall not apply for claims for salvage or contribution in general average. And the point Mr. Justice Sheen had to make was simply because underlying the claim to an indemnity is a claim for salvage. Does that engage Article 3A? And he said, well, obviously not. The claim that the salvors make is a claim for salvage. The claim that the charterers of the cargo owners were making was a claim for damages in the amount by which their interest in the cargo was diminished because it was encumbered with a lien in favour of the salvors. So he said this is not excluded from the Convention by Article 3A. But he did then have to go on to consider whether it was included within the Convention by any of the provisions of Article 2. And he set out at page 222, bottom of the page, he set out, for these reasons, the claim of the cargo owners for damage consequent upon the ship owner's breach of the contract is a claim within subparagraph A. So he's held that the cargo has been damaged by reason of it being encumbered with the lien in favour of the salvors. But he then says, in case I'm wrong on that, I turn to Article 2.1f. And at the right-hand side, he quotes 2.1f. He says, accordingly, their claim for damages is a claim of a person other than the person liable, the ship owners, and is in large measure in respect to the measures taken in order to avert or minimise damage to the cargo, for which the ship owners may be entitled to limit their liability. Such a claim falls squarely within the natural meaning of subparagraph F and is therefore subject to the ship owner's right to limit their liability. And he's got to that conclusion because, in this case, we're only dealing with cargo owners' share of the salvage. And he said earlier, immediately put my finger on it. Can I have just one moment?
Well, he's made the point that liabilities are several.
That was the passage I was looking for, but I couldn't immediately find the word several. He's made the point that the liabilities are several, and it's trite law that the cargo are only responsible for their share of the award. So he's saying there's...
It's 220, right-hand column, just opposite the word judgment.
I'm grateful, my lord. I was looking too far on in the judgment. So he's made the point that the liability is several. And 2.1f in this case is engaged because it's possible to identify a cost that is mitigating the loss and only the loss in respect of cargo. And this comes back to the point I think my lady was debating with my learned friend yesterday. And our submission, in short, is this, that 21F is engaged if you have a cost that is only referable to mitigating a loss that would be limitable. If you've incurred a cost that is partly to mitigate, or been exposed to a loss, which is partly to mitigate a claim that would not be a loss claim for which would not be limitable, and partly to mitigate a claim for a loss which would be limitable, then you cannot get within 21F, because otherwise you would be enabled to limit for a cost that was, at least in part, not within the limitation regime. You are mitigating a loss which wouldn't itself have been limitable. And so what my learned friend has to show in our submission is that the costs that he seeks to limit under this head were made in order to avert or minimise cargo claims, i.e. claims for which there would have been a right to limit. And one can see that also, again, in the judgment of Mr. Justice Thomas in the Aegean Sea. Where he dealt with at page 239, the right-hand column of page 55. And in relation to the salvage, picking up in the left-hand column, ROIL contended that the claim for indemnity in respect of amounts paid to the salvors was a claim in respect of a loss consequential on the loss of the ship or the cargo, and therefore within 2.1a. For the reasons I've given, the loss of the ship is not within 2.1a, then the consequential claim is not within it. However, it is clear that the salvage payment was in a material part in respect of the cargo, and that part can properly be characterised as consequential loss resulting from the loss of the cargo. So, Mr. Justice Thomas has ruled, because of his headline point about limitation between owners and charterers, that charterers can't limit at all. But he said, if I'm wrong on that, then under 2.1f, that part, which is properly categorised as consequential resulting from the cargo, could be limitable. But the part that is categorised as properly related to the ship cannot be limited. And that requires, in our submission, MSC to be able to identify a specific part of the claims which relates to mitigating the cargo loss and not our loss, the damage to the ship. And in the salvage context, as my Lord Justice Mells has just pointed out, it's possible to do that because the two parties are severally liable for their own share. But that division can't be carried out in respect of either of the costs that my learned friend seeks to limit in respect of. I say it can't, I suppose it possibly could, but he doesn't attempt to do so. And having not attempted to identify those parts which are costs of mitigating the cargo as opposed to costs of mitigating the ship damage claims, he has no right to limit under 2.1f. And that is essentially why the judge said, use the word solely. My learned friend says that the word solely is, again, he says, a gloss on what the convention actually says. But it isn't, in our respectful submission. It's just the judge's way of summarising his conclusion on the proper meaning of 2.1f. which is that you have to have a loss, a cost that is incurred in order to mitigate a limitable loss. So just to apply that, if I may, to the two heads of loss which my learned friend says are limitable under 2.1f. The payments to the national authorities, did we make those payments in order to avert or minimise cargo claims, i.e. claims for which there was a right to limit? And the answer we suggest is no. We made them in order to get permission to transit the English Channel. And we had to make them because of the risk of bunkers escaping from the damaged vessel. Insofar as we made those payments with cargo in mind at all, it was so that we could get cargo to Wilhelmshaven and discharge it, so that we could repair the vessel. And the need for all of this arose because the vessel was damaged and the voyage had to be abandoned. And as I've said, the voyage had to be abandoned because of the damage to the ship. And the payments, as I said earlier, predominantly in the nature of payments under the Bunker Convention. And so the costs paid to the national authorities are at least as much, if not more, costs of saving and repairing the vessel as the salvage costs and repair costs which my clients incurred and which MSC accepts it can't limit for. So my client's share of the salvage award, MSC no longer seeks to limit. Repair costs, MSC no longer seeks to limit. And on that basis, we would suggest that the costs paid to the authorities for obtaining permission to transit the Channel to Wilhelmshaven are equally not limitable. And broadly the same points apply, we say, in relation to firefighting water. The firefighting water was used to bring the fire under control as part of the salvage operation by which Smith Tack were obliged to use their best endeavours to salve the ship and the cargo pursuant to the Lloyd's form. I took the court to the judge's findings of fact on this yesterday, and I don't propose to go back to them again, but I made the point that he found it was at least as much the motive for engaging salvage services, at least as much to do with the vessel as to do with the cargo. But even if it was equally, the water was used indistinguishably in relation to saving the ship and saving the cargo, so that the vessel could be repaired and returned to service. So spraying the firefighting water onto the ship was not a measure taken to avert or minimise loss for which MSC would be entitled to limit. It was a measure taken in order to salve the ship, which had the additional side benefit of mitigating a loss for which MSC would be entitled. And that is, in our submission, not enough to engage 2.1f. And so the judge did not read the word solely into 2.1f. He used it by way of an explanation as to what he understood the words in respect of and in order to mean. And if I could ask the court to go back to 2.1f, it requires there to be a cost at page 100 in respect of measures taken in order to avert or minimise. So the use of the word solely by the judge simply meant that he understood those words to mean only in respect of and only in order to. And that, in our submission, and consistently with what Mr. Justice Thomas said in relation to the salvage claims in the Aegean Sea, requires one to say, have you identified a cost that is only in that respect? Even on MSC's case, skeleton paragraph 44, at page 279, they say that the correct test is to consider whether the mitigation of a limitable loss is a substantial or significant cause of the expenses being paid. And again, we submit that whether one is looking at the firefighting water or the costs paid to the authorities, it is not for the reasons that I've already given. And because, again, Article 2.1f, as the judge said, is intended to assimilate the costs of mitigating with the limitable loss that is being mitigated, that's the judgment at paragraph 150, which Malone and Friends at paragraph 42 accept, is the correct approach. But the difficulty for Malone and Friends is that if their approach is right, you're assimilating not only the costs of limiting the cargo claim, for which there was a right to limit, but also the costs of mitigating the damage to the ship, for which there is, we all agree, no right to limit.
Yes, what was your judgment paragraph reference there, please?
42.
42, thank you.
So Malone and Friends' approach fails, we would suggest, to sufficiently distinguish between the reason for incurring the cost and the consequence. So my client's reason for incurring these various costs was, as we've said, because of the damage to the ship and the need to repair her. If the consequence was also to mitigate the cargo claim, that doesn't bring it within 2(1)(f). Put the matter the other way, if, as we submit to be the case, costs incurred in relation to damage to the ship is specifically outside the limitation regime, it would not be appropriate to allow those costs to come within the limitation regime through the back door, because costs were incurred for what could be called a dual purpose. And that, Malone and Friends give an example at paragraph 43 of their skeleton. Which, if we could just turn up at 279 briefly. And this is another one of their public authority points. They say, suppose the public authority takes a measure to mitigate a limitable loss, for example, by moving cargo from A to B, where it was exposed at A and not at B. It would be protected from further loss. If protecting the cargo was the only reason why the measure was taken, then on the judge's interpretation, the owner and the charterer against whom the claim is made can limit. Now, if the public authority was moving the cargo both in order to prevent damage and for its own convenience, then the judge's interpretation, the owner and the charterer would not be entitled to limit. And they say there could be no sensible rationale for adopting an interpretation that has this effect. And in our respectful submission, the sensible rationale is that otherwise the charterer can limit, or on this posit, the charterer or the owner can limit for a cost which was incurred for a purpose which is not within the limitation regime. And that is the sensible purpose. And so, for all of those reasons, we would submit that Article 2(1)(f) is not engaged on the facts of this case as found by the judge. But one final point to deal with in relation to 2(1)(f) is that, again, I think this was a point my Lord Justice Males made in argument yesterday. Malone and Friend suggested that no one had ever suggested that there could be an apportionment. And the question arose about the 900,000 against 20 million, the respects in which the different salvage costs are being paid. And it is, with respect, not quite right to suggest that nobody had ever suggested that there could be some kind of apportionment. In our skeleton argument at first instance, we did submit that if 2(1)(f) was engaged or potentially engaged, the only way it could operate is if MSC sought to apportion or identify the costs within these two heads that were cargo related rather than ship related. And that was based on what Mr. Justice Thomas said in the Aegean Sea, and based upon, and the judge made a direct reference to this as well, where he said whether there were distinct costs could be identified. And so we did float that suggestion. We didn't advance it as a positive case. It's obviously not in our interest to do so. But my learned friend did not pick up the suggestion and say, okay, I will try and identify a part of the cost of going to Wilhelmshaven or a part of the cost of the firefighting that is cargo as opposed to mixed. He didn't adopt that approach at first instance. He didn't pick up on it in his appellant's notice. and he hasn't established that, and it would, on our submission, be for him to say, yes, I can identify part of the cost which is distinct and therefore does come within 2.1f. And particularly the judge, just last comment before I sit down, at paragraph 150 is the reference to the passage I just mentioned, which is at page 81 of the bundle. Says, concluded, and we invite this court to take the same approach. The correct reading of Article 2.1f in its context is given its evident purpose of assimilating for tonnage limitation purposes claims for compensation or recompense in respect to the burden of mitigation with claims of compensation in respect. Well, I've picked up the wrong reference. Sorry, 150. Should have read the previous paragraph. Beginning at page 81. Even if contrary to my primary conclusion, the correct way of looking at things is to treat Conti as having made a separate claim for that cost. MSC cannot establish that the claim is distinct from the non-limitable category of claims in respect of which the loss or damage to the ship. So, and then the judge went on to his conclusion that I was reading. And so the judge is essentially saying, you haven't even attempted, and indeed you cannot establish a distinct loss that is referable to mitigation of a limitable loss, and therefore you can't engage 2.1f. And so, my lords, my lady, unless I can assist further, those are our submissions on why none of the four heads of claim are within the convention.
Thank you very much. Mr. Kenny.
My lady, my lords, I'm going to start with the insiders, outsiders point in its latest iteration, and then I will deal with the global characterization question, and then the heads, the individual heads of limitation within Article 2. As regards the insiders outsiders point, our submission is it stands and falls, stands or falls on the question of whether there really is an absurdity to which this might be a remedy. Is there a disease in the convention which needs the Smith remedy of qualifying which claims can be made? And we said to you yesterday, there isn't, for the reason that the judge gave in paragraph 85 of the judgment, namely that the party which establishes a limitation fund has a claim against its contractual counterparty for the cost of putting up the fund, which is not limitable. In other words, put in very simple terms, imagine there's a casualty. Imagine an owner puts up a fund by paying £10 million into court. It has a claim against the charterer that it says is responsible for the casualty for the cost of doing so. And how exactly that claim works out, I mean, in practice what happens, because this is not an unusual feature of this area of the law, in practice what happens is an arbitration is started between the owner and the charterer, in which the first head of losses, the cost of putting up the fund. The fund is in practice always put up by way of security, and the party that wins the security, if the owner succeeds against the charterer and establishes that the charterer was responsible for the casualty, the charterer will simply put replacement security to provide replacement security to the court to act as the fund. So essentially, the contractually responsible party ends up putting up the fund.
I mean, security is often provided by a P&I
Exactly.
letter.
Yeah.
Is a claim for the cost of putting up a fund
So
within standard P&I cover?
so the whether it's within standard P&I cover, I know somebody's going to be able to give me an answer, but whether it's a question of the P&I club in its discretion providing the security necessary by way of a P&I club's letter of undertaking, or whether they're obliged to do so under their contract with their assured, I can't tell you, but what I can tell you is the way in which, in practice, it will work is that let's suppose it's the ship owner who establishes the fund. He brings a claim against the charterer saying, you're responsible for this casualty, and I want indemnification against all my costs, whatever they may be. If the ship owner succeeds, and it's established that the casualty was brought about by the charterer's breach in shipping dangerous cargo, whatever it may be, then in practice, the charterer's insurer will provide a replacement letter of undertaking. Says, okay, I appreciate now we've got to pay the limitation amount, because, and that, although what's happened is the fund is established originally by a letter of undertaking from one party's P&I and it's then replaced by another party's P&I, essentially what's happened is a claim has been brought, in legal terms, a claim has been brought by the owner against the charter for indemnification against the cost to it of establishing the fund. And if you ask the question, when the owner who's established the fund sues the charterer and says, I want to be indemnified against the cost of providing this fund, can the charterer say, no, I'm limiting, and you must look to your own fund to pay this claim? And the answer is, of course he can't. And that's exactly what the judge says. So let me address head on the point that, as always, gives an advocate the most worry, which is the point that the chairman of the tribunal puts, which is the judge's solution in 85 rather convoluted and out with what the parties to this instrument could have imagined? The answer is no. It's a routine part of the business of limitation. And just, although I've perhaps done this already and I don't want to labour it in reply, just suppose the most bread and butter or plain vanilla case. There is a casualty in which a great deal of cargo is damaged or destroyed. As between the owner and the time charterer, they don't know which of them is responsible. They blame each other. The owner, because it's facing claims, establishes a fund, and it then brings a claim against the charterer saying, I want to be indemnified against the costs of putting up this fund. It just cannot be the case, and indeed it is not the case in practice, that the charterer could, in response to that, say, but you've put up a fund, and your claim against me for the costs for indemnification against the costs of putting up the fund are somehow limitable. It's not, and that's not the law. The alternative, you would have to suggest that way of doing business is not the way it works between owners and charterers. You'd have to suppose that the charterer, in that case, would be able to meet the owner's claim for indemnification against the costs of putting up the fund by saying, that claim is limitable. And as I said to you yesterday, well, under which limb of Article 2.1 is that going to happen? But let me just make one other point about this example. What this example shows you is that the Smith patent remedy doesn't cure the disease if there was a disease, all right? Because the case we've supposed just now is a case where the owner has put up a fund, and no, the owner has put up a fund. Owner has put up a fund and has brought a claim against the charterer, and the charterer responds to it by saying, look to your own fund. And Mr. Smith's submission is that's an absurdity which calls for a solution. And that's why we're going to ban claims by one member of the shipowner class against another. But he didn't say ban in toto. What he said was ban claims by one member of the class against the other, except recourse claims. Remember, there was a qualification. But this is a recourse claim, right? So the plain vanilla case where an owner has set up a fund and now, as Mr. Smith would have it, has to look to the charterer for reimbursement, is then told to go to the fund. If that's the way it works, of course we say it doesn't, it is not cured by the solution he's proposing. The solution he's proposing has a hole in it for recourse claims. It still permits the limitation between members of the shipowner class of recourse claims. So the one thing that indisputably the judge got right was what he said in paragraph 85 about the way in which the settlement of claims between parties to charge parties works, where a fund is set up. And if he got that wrong, then the supposed absurdity in this is not an absurdity which is cured by the implication that Mr. Smith wants to make into the text of the convention. Now, repeatedly through the argument on this point, the Conti refer you to Mr. Justice Thomas saying, in circumstances where there is aggregation of claims as provided for in Article 9 and Article 11, it's very difficult to see how there can be limitation of claims between members of the shipowner class. But you have to read those comments bearing in mind this, that this point about how claims for the cost of the limitation fund are settled between parties to charge parties was not before the court in the Aegean, and there's no evidence that that argument was put to Mr. Justice Thomas. He's commenting, and of course one respects a distinguished commercial judge, in all fields, for the view he's taken of the instrument. But the point wasn't being argued. And what he says about what's difficult to see may be premised on a failure to appreciate how the costs of limitation are settled between parties. I mean, he is definitely pointing to the disease that Mr. Smith says is in the convention. And if he's doing that, he's missing one piece of the puzzle, which explains why it's not a disease at all. Right, so that's our submission on why in fact there is no urgent need to write text into the conversion, into the convention. I apologise. It works fine as it is for the reasons that the judge correctly identified. I then come to the proposed reading of the text, and one of the telling aspects of the owner's developing case on how Article 2.1 should be read is that they never gave you a paraphrase. They said, well, it shouldn't include claims by one member of the ship-owning class against another member of the ship-owning class, or at least it shouldn't permit claims other than recourse claims by charterers against owners, although it does it does permit limitation by charterers against owners, but not owners against charterers. And you just have to test whether this is a viable reading of the convention. Open the convention and see where you would read those words in. I mean, presumably, it's going into Article 2.1. And do we read the first sentence, which says, subject to Articles 3 and 4, the following claims, except claims by any member of the ship-owning class apart from registered owners against another member of the ship-owning class other than recourse claims. It's just an impossible task to try and get any of those words in. And it's doubly impossible once you say, because remember, this reading in involves treating owners, real owners, differently from the other members of the ship owner defined class in Article 1.2. But who's a real owner? Do you mean the registered owner? Or do you also include the demised charterer? Is it seriously the case that we're now going back to reading this convention in a way that treats demised charterers differently from registered owners? That hasn't been done since 1896. 1895, is it? So you just say this is just, it's a wildly ambitious piece of statutory construction, which, for understandable tactical reasons, Mr. Smith has never sought to condense into an actual proposed text. Right, that's all I'm going to say on the insiders-outsiders point. I'm going to move on to global characterization of the claim. And Mr. Smith's submission was the judge was not attempting a global characterization of all the claims. He was merely arriving at the conclusion that all the claims he had before him shared a common character. Now, you've been shown the critical passage in which he makes the relevant comments, and I made my submissions about what he seemed to be saying yesterday. But just for your note, you may also want to see paragraphs 115 and 116 of the judgment. Where, in our submission, it is quite plain that the judge has made a global assessment of the claims, because he says it was a claim in respect of damage to the ship that's not limitable. And then he says, in case it was necessary to do so, Mr. Smith's argument also engaged as with E and F, as variously relied on by MSC, under MSC's approach of taking various groups of expenditure separately, treating Conti as having made a series of separate claims, and exploring whether they could be said to engage 2.1 E or F, as the case may be. And then he said, well, I'm going to go with that approach. Now, in our submission, that is making quite clear that he's taken the contrary approach at the earlier stage of the judgment in which he, which we've looked at. That is, in paragraphs 101 and following. And to the same effect, we just, when you're considering this point, ask you to look at paragraphs 163 and 164, which again, we trouble you to look at it, spend time looking at it now, but again makes clear in our submission the judge has attempted, or has taken a view that there is a global character which my Lord Justice Mills may have been correct to say was a view about the nature in law of the claim advanced in the arbitration. And as to that, we've made our submission that that was not the way in which the claim was advanced in arbitration. Mr. Smith laid emphasis on the Ocean Victory and the mystery 8 heads of loss that comprised the repair costs in that case. Our short submission is about that. I mean, obviously we don't know what's in Pandora's box. All one says there are 8 heads of loss. I mean, that may have been the propeller, the funnel, the paintwork. But in any event, that case doesn't assist us on this point because it was only argued on the basis of 2.1a. Wreck removals couldn't have been argued on the basis of 2.1d, as Mr. Smith very fairly acknowledged, because that's not part of English law. The only point in amongst the known heads of loss that might have raised the question that you have to decide today was one that wasn't available to the limitation claimant because D was not incorporated into English law. Sorry, was... Oh, I apologise.
Well, just in case you need to
You said the Ocean Victory. We think,
I think
you're being reminded, and I think you meant to say
you're not the only person who pointed out my mistake.
Yes.
In which case, my point is good as far as they're simply unknown as to what they were. Yeah. All right. I come to therefore to 2.1e, and insofar as you ask yourself the question, what are the facts on which the claim that these were costs of removal and making harmless of the cargo that the limitation claimant MSC relies upon? And the facts are, as I said in oral argument yesterday, those in 11 to 14a of the quotation section, and in particular, critically, the agreed fact that because the ship was unable to complete her voyage, this is 11, Conti arranged to discharge her cargo at Wilhelmshaven. The salvageable cargo then had to be decontaminated and either transshipped or released directly to cargo interests. The unsalvageable cargo and the salvageable but unclaimed cargo had to be destroyed. And there were costs incurred in performing those tasks. It may be more relevant to the decision to go to Wilhelmshaven and the costs of going to Wilhelmshaven but we also rely on the judge's finding in 8.3, which is that although the reason strictly the reason that the vessel was unable to complete the voyage was because of how damaged she was, even if the ship had been undamaged or much less damaged, diversion to Wilhelmshaven to deal with the wrecked or badly damaged cargo and the byproducts of the firefighting effort, it would surely have been necessary the byproducts of firefighting effort, rather than direct praise center, would surely have been required. And then finally, in this context, we rely on 112, which is in relation to the submission that the cargo and the ship could have just been abandoned. And the judge finds, on the basis of the evidence, that in all probability the ship would not have been abandoned, even if the decision had not been made to repair the ship. That in fact the owners were going to repair the ship, so it was the case that everything they did was for that purpose. But even if they decided not to repair the ship wouldn't have been abandoned. The owners would have done the things that they did in any event. Now, I take the point. You don't know exactly that would have happened on the same day, but if you say, did they have two reasons for doing it? Yes, because these things had to be done. All right, so those are the facts in relation to 21E. As regards to the construction or interpretation of 21E, Mr. Smith lays evident emphasis on the idea, which obviously had some appeal to the judge, that the kind of removal we're talking about is not just routine removal in the performance of an ordinary voyage, although, as Lord Justice Mayle said, perhaps that's not something one has to really consider, because it's very difficult to imagine how the costs of routine discharge could ever get anywhere near the limitation. But it's not just that, it's some kind of post-casualty, to which my submission is that may well be right, but this was post-casualty discharge. Whatever frame you want to put around it, whether you say it's got to be post-casualty discharge or special discharge or some special procedure, this was discharge not at the port of destination, after the abandonment of the voyage, with a cargo that was contaminated and which had to be cleaned up and released. And what's happened is the judge has perceived a square hole and attempts to insert a round peg, because he then says, so my solution to this is that it can't be discharge by the charterer or anyone involved. Why should the charterer or someone else involved in the charter not be providing the kind of special discharge that constitutes removal within 21E? As to Sir Launcelot's point about the difference between the meaning of removal and discharge, I made the submission yesterday, I make it again briefly today, that removal is simply the wider term and embraces the lesser. So removal is designed to cover all kinds of taking off, taking out, taking away. Discharge is more narrowly taking out of the ship. As to the Aegean seas and the question of the application by Mr. Justice Thomas to pollution cleanup, in case it troubles you as you try to rationalise this, that was clearly a case in which the judge would have applied 21E to costs of making harmless cargo that was no longer identifiable as such. All the little molecules of oil were now spread around the beaches, and it was not a cargo of oil in any ordinary sense. We recognise that by parity of reasoning, we might have put a claim for limitation under 21E in respect of the water, which which contain many dirty molecules of burnt cargo and burnt waste. We have not done so, don't seek to change our case now. That may be a wrong concession by us. We don't say that Mr. Justice Thomas was wrong to conclude that 21E applied in the case that he did. We just haven't sought to put our case in that way. One puzzle you don't have to solve in this judgment. The examples, very briefly, Mr. Smith says it's difficult to imagine how an authority could act on behalf of the ship. We'll have to rely on your deep knowledge of global provisions for harbour authorities, but our submission is it is not at all unusual that public authorities have statutory powers to do things on behalf of property owners. Whenever you obstruct the highway, the obstruction is removed on behalf of. Whenever you allow a listed building to fall into disrepair, whenever you provide a nuisance, there are provisions which permit an authority to act on behalf of. As for the bill of lading holder, he would have done it anyway. Well, he assuming special discharge, he wouldn't have. The short answer. This was discharge. Assume that the discharge had been done by the bill of lading holders here. This would have been discharge of burnt cargo and not at the port of destination. Again, we say that's a pertinent example for why, when you, as the judge does, and Mr. Smith would have you do, introduce a qualification like, but not discharge by the ship, meaning anyone involved in the operation of the ship, you introduce a gloss of uncertain ambit. 21F. The facts, just so that it's clear what we rely on, I just repeat them, are those found by the judge in paragraph 6 at paragraph 43 about the engagement of the salvors, at paragraph 8 about the circumstances in which the voyage was not completed, particularly 8.3, that it would have been necessary, whatever the damage to the ship, to go to a port of refuge. And paragraph 10 then about the expenditure, and the paragraphs 16 to 19 about the water removal. We also rely on paragraph 149, which is the judge's finding that, as we would put it, these were concurrent, that the reasons for engaging the salvors were both to save the cargo and to save the ship. And we would describe that as two concurrent sufficient causes. The ship had been unloaded, if one can imagine a huge fire on an unloaded ship, but if the ship had been unloaded, the salvors would have been engaged. If there had somehow only been cargo floating out, or only the cargo was in danger, the salvors would have been engaged. Both were endangered. Both were sufficient reasons to justify the engagement of salvors. And put starkly, and making a submission by just identifying the issue, you are ultimately, on this point, on 21F, asked to decide whether, in a case where there are two reasons for taking some mitigation measure, one of which is to mitigate a limitable loss, and one is to mitigate a non-limitable loss, whether the requirements of 21F are satisfied. And our answer is they are, and you should find that they are, both for the grammarian's reason that I gave you yesterday, which is that where you express a reason for doing something without qualifying it as solely or only, that statement is not taken to be exhaustive. You're not saying it's the only reasons I'm doing it. The reason I went to the British Museum was to see the Sumerian exhibition. That's not the only reason I went. It's not implicit. But more generally, because that is consistent with the purpose and the approach to construction, which Mr. Justice Thomas tells us is the correct approach, and it's the passage you've looked at already, 230 of the authorities bundle in the Aegean Sea.
Interpret as limitable where you reasonably can, is that
Exactly, exactly. And for all that Mr. Smith would deprecate Victrol and Justin Chambers as predating the Vienna Convention on Interpretation Treaties, that statement does not. And that statement is guidance based on Supreme Court authority as to the approach to be taken to a limitation convention. So there is a sound reason in the policy of the convention for, faced with this fork in the road, taking the path that leads to effective rights to limit. And of course, two short further points. What Mr. Smith says is, well, if you do that, you're assimilating a measure, the costs of a measure taken for a reason, or for the purposes of mitigating a non-limitable loss. And I recognise that's a necessary corollary of my submission. But equally, if you take his course, then you're assimilating the costs of a measure which was taken for the purposes of limiting a limitable loss to non-limitable loss and refusing a right of limitation. I mean, it's one submission is the flip side of the other. There is an inevitable imperfect match between the objective of assimilation and the reality in case of concurrent causation. You've just got to choose which path to take. And then finally on this point, Mr. Smith chides us with not having taken up his invitation to apportion the loss insofar as they were distinct. And we just say there's a very important difference between severing a loss where losses are severable, which is the case of salvage awards, where there is a severable, there are in fact two awards, one in respect of the charterer's portion and one in respect of the owner's portion, and apportioning a non-severable loss. When he adds in the word distinct, that's only a word that is apt to describe a severable loss. If it's a distinct loss, of course, if I could say, well, look at the short stop that they made at Antwerp to pick up the cargo documents on the way to Wilhelmshaven. You know, that's a distinct loss which related only to the problems of the cargo. Well, distinct in that case means severable. That's one which can be treated differently. The problem of concurrency only arises where losses are non-severable.
You say this is an indivisible loss which was incurred for dual purposes, and we have to choose whether that's within F or not.
You put it exactly as I would like to put it. And it may be that an indivisible loss is capable of apportionment in some context. For example, blame is apportioned under the Contribution Act, under the blame may be apportioned under the Contributory negligence regime, but nobody has suggested that there's any juridical basis in this case for apportioning an indivisible loss. As regards A, finally, the facts that we rely on for A are those found by the judge in 8.3, and then, sorry, so that's 8.3 of the quotation, 43, and then 11 to 14A, and then the 22, and which is the German law obligation, and then 23 to 30. Put shortly, the factual basis as regards the claim for the costs of discharging and dealing with the cargo under 2.1a is that the cargo was physically damaged by the contamination, smeared with some kind of chemical residue that needed to be removed, or literally physically damaged because the containers were bent or crushed, or in the case of the unsalvageable destroyed. And the consequences of that, even as regards the most minimally affected cargo, was that the cargo was devalued and in need of being rescued in order to be released. And we say there's an obvious analogy as regards the least damaged cargo with the cargo that was under the Salvers Leon in the Braden Merchant. And that's page 376, column 1. But you remember that you were shown by Mr. Smith that passage in which he says, well, the cargo that was under a Leon was damaged because it was subject to legal constraints which it hadn't previously been subject to. So that's the basis of the claim as regards 2.1a, and as regards the claim for two claims that we put under 2.1f, we say the basis is broadly the same. These were cargoes which were in the process of being damaged or in a damaged condition, and the consequence of that was that they needed to be rescued in the way that they were by being brought to Wilhelmshaven and extinguished. And the consequence of the extinguishing and rescuing of the thing was the loss in the form of the need to remove the water. Finally, as regards the burnt waste, we simply say it was the consequence of the damage to the containers that were destroyed by the fire that they left a residue which needed to be disposed of. So that is the simple factual findings on which we found our claim to limit under 2.1a. As regards APL, the APL Sydney and the Derrington and Turner, we're in a slightly unusual position here because that was a point on which the judge reached a conclusion, and no respondent's notice was submitted against the conclusion he reached on that point. But it smacks somewhat of creative last-minute thinking to revive this. But we say for three reasons the judge's conclusion was obviously right. First of all, the Aegean Seas is authority for what Derrington and Turner described as the wider view, which Justice Finkelstein subscribes to. And that is made clear by the judge in his treatment, but just very briefly to give you the references. Page 227 shows you what the loss was.
Are we in the authorities bundle?
In the authorities bundle, yes. I'm going to show you the G&C. So 227. Right, and the critical paragraph here is column 2, under the heading Owners' Claims Against Royal as Charterers, subpara 4, they want an indemnity against claims for property damage, property clean-up costs, loss of use and loss of profits claims by fishing boat owners. Well, maybe the fishing boat owners were physically affected, although more likely the problem is the fish they were going to take out. Yacht owners, fish and shellfish farmers, maybe their farms were affected. Shellfish harvesters. Okay, now, shellfish harvesters definitely didn't own any property. I mean, unless it was compensation for having to take the oil off their tools or something. Fishing net and fishing pot owners, well, they could have been direct. Shop owners, right? That is definitely not in the property owners class, unless somehow the oil was spraying up into town. And local municipalities, the government of Galicia and the state of Spain. So what we say about that is a list that plainly includes people who did not own property, who are nevertheless claiming losses, and the judge finds at 236 column 2, second paragraph, that those claims, starting ROIL contended, the 3 claims. He says the claims for direct damage by the pollution are either claims in respect of damage to property polluted by oil, or that damage to the property as well as the cleanup and French costs, and the loss of profits claims are consequential loss claims within 21A resulting from the loss of the cargo. So all the claims for an indemnity succeeded, including, it appears, the claims by people who were not owners of any property that was affected. And that is therefore, to add to the APL Sydney, a case in which consequential loss has been held to embrace the economic losses suffered by persons who were not owners.
Albeit related to the physical damage caused by what came off the ship.
Yeah, but not of their property.
No.
That's the critical point.
I have that.
That's the critical point. The second point against this is that the test that Conti are now proposing for 21A, i.e. that it permits limitation in respect of damage to cargo only of claims by owners, it is a claim that is hopelessly ill-adapted to the real world of claims between charterers and owners. Because while it might be true to say that if all you were considering was claims by bill of lading holders, the bill of lading holder might, whether has full title or whether he merely has an immediate right to possession, be said to have proprietary right to the cargo, which is part of his claim against the owner for damage to the cargo. it's absolutely routine that charterers have no proprietary or possessory interest in the cargo, but have substantial losses flowing from its damage. Just imagine the case of an FOB seller who sells cargo which is at his risk during transit. Doesn't have any property in the ship, but he's liable to suffer loss. Now, that may be within the judge's test of economic interest, but it's not within Mr. Smith's test of which would confine 21A to claims made by owners and economic loss suffered by those owners. So whether it's as a matter of authority or whether it's just by looking at the practicalities of a system of limitation which must apply to cases of claims brought by charterers against owners, it just can't be right that 21A is confined in the way that Conti now suggests. And then finally, although this is more aimed at the judge's dismissal of our case on 21A on the basis, as he would have it, that Conti had no interest, economic interest, in the cargo. You say, how can that possibly be right? Conti was the bailee of this cargo. They were in possession of it, and if the cargo was damaged or destroyed, it was obviously likely to result in costs, liabilities for Conti. The suggestion that the owner of a ship carrying a cargo has no economic interest in the cargo such that he is not harmed by the cargo being damaged is heretical and there's no relationship to the reality of trade. The owner of a ship on classical authority would be able to sue anyone who damaged the cargo, I'm thinking of the Winkworth, on the basis that as a bailee of the cargo, he's entitled to claim as if he had full title. And a person in that position can't possibly be said to have no economic interest in the cargo and not to be harmed by its being harmed. So again, we say there's no foundation for the judge's conclusion in this context, but conclusion which Mr. Smith repeats.
And was sued in the United States.
Precisely.
Albeit unsuccessfully.
Yes, exactly. So we say that on the suggestion that 21A be read down in the way suggested by inserting the word owner. Just like every good children's party, there's a going home present. This is the case that Mr. Smith referred to earlier, which is the Liverpool, and for your note, at page 75, column 1, top of, the Court of Appeal draws the analogy between limitation and a statutory insolvency, and refers to a House of Lords authority in which that analogy was drawn. Of course, we say this is not a perfect analogy, in as much as it doesn't involve all the assets of the ship owner, and it is only semi-obligatory because a claimant may try to bring claims against the ship owner other than against the limitation fund, although if he does so in a jurisdiction that recognises the limitation fund, he will be redirected to the limitation fund. So while we say it's not a perfect analogy, it is part of the policy of Parliament in adopting this convention and applying it, that a system akin to statutory insolvency be applied for maritime casualties. Otherwise, those are our submissions.
Well, thank you very much. Thank you both very much, and thanks to those supporting you from behind. We will reserve judgment. When the judgment is ready, it will be sent to those whose names have been given to my clerk. That will be, as I'm sure you know, for the purpose of correction of any minor factual or typographical errors, and the embargo which will appear on the face of what is sent to you is something that the court takes very seriously. We will hope and expect that in the light of the judgment you will be able to agree an order for us to approve. If you can't, then we will have short submissions and we will resolve whatever issues there are without a further hearing. So with thanks again, that concludes the hearing of the appeal.